Yes, Lolita, I could hear the clock ticking in the back of me. I hope it's a good tick and not a bad tick.
Man, listen, it better be. Ah, boy. Hopefully we have another short meeting today. I have a funeral this afternoon.
It would be lovely short, but every place I have to go close between 12 and 1 o'clock.
Oh, Lord.
Well, except the hair salon, but every place else close.
Good afternoon.
Hi, Christine, how are you?
I am fine. Very fine.
Good for
Okay.
you.
Yes. Last class. I'm very fine.
I was just saying there's light at the end of the tunnel.
The only definition of wealth that matters.
Good afternoon.
Okay. Good. Good. Okay.
It's 5 more people, so I don't know how much Kelly number of people it was. So,
Yvette, did you send in your homework? Or you didn't get a chance to do it?
I did not send in my homework.
But you did it though.
No, I didn't do it.
What?
I reviewed the questions. I will participate in class, but I did not submit it. So
I have, then is she on? No. Yeah, Kadrin is on. All right, so let's start with the first one. Powers of management are vested in directors. They and they alone can exercise those powers. Who wants to start first? I have Kristen's answer. Kristen says, directors shall exercise their right bona fide in the interest of the company. The directors, while exercising their rights, do not act as agents of the members. So the members cannot, by resolution passed by majority or even unanimously, supersede the directors' powers or instruct them how they shall exercise their powers. In the above case, as the independent director was placed in charge of the company's financial matters, therefore he was fulfilling his duties when he requested the unpaid share capital contributions to be paid by the shareholders, as those amounts were outstanding liabilities of the company. So even though Peter and John filed a resolution, it didn't give them the right, as the powers were already granted to the director, and he was performing his fiduciary duty to the company, acting at its best interest. The only way to move forward was that they would have had to either try to remove the director or to amend the powers given to him in the Articles of Association. You agree with her answer? Okay, Kadrin has the same thing.
Well, I don't know, that sounds like a very good answer, but that don't just look like no question that I received. I must do the wrong thing.
What you mean? For unit 7, that's the first question.
Oh, okay. I remember seeing no Peter and John, no man my question, but
No,
that sounds like a good answer.
no, Peter and John is in the actual case, Shaw and Shaw.
Oh, okay, the
Yes.
one that Graham made the comment on when he said
Yeah.
that, yeah, okay,
So if you read that, then you find out Peter and John.
okay.
Yeah, that's where that came from. Okay, the next one is explain the degree of skill and care which the law requires of a company director.
Sorry, you didn't say your comments on the answer. I thought that it was adequate. What did you think?
It was adequate, but I had a couple more that.
You see, that's what you need to tell us.
I forgot I didn't add that in. My couple of points. Now, remember that there is always, when you're looking at the members versus the directors, there's always a chance that you can go back to the memorandum and the articles to see whether or not you can actually make some division in the powers. So looking at the articles and the memorandum, you can tell whether or not there are certain powers reserved to the members. And when you read the articles, you know that certain powers that are reserved for the members is to alter the memorandum and articles. They can alter the share capital. They have the power to appoint auditors, you know that, remove directors, and the power to put the company in. You could also refer to Table A. And Table A would also reserve certain powers to the members, like such as their particular rights to be attached to the share issue, or variation of those rights, or declaration of dividends. But sometimes the members and the directors have concurrent powers. So even though they were given to the director, sometimes they could be regarded as concurrent and exercisable by the members unless the articles make it clear that that power was exclusively for the directors themselves. So a power for directors, let's say to appoint additional directors and to fill casual vacancy on the board. Or there could be a power for directors to fix the remuneration of the managing director. They could be treated as concurrent powers, unless the articles clearly state that those are exclusively for the directors. So even though in Shaw, the Court of Appeals declared that the resolution of the company directed against the 3 defendants was to be invalid, the court held when the general management of the company belongs to the directors, the shareholders have no power by ordinary resolution to give directions to the board or to overrule their decisions. Unless, of course, that power is a concurrent power. So the articles clearly show that it is to be exclusive to the directors, and so resolutions passed by members in respect of such matters will prevail over the director's own decision. Although the directors have power to sue in the company's name, if there is a concurrent power in the members. So that if the board decides not to sue in a particular case, the members, by ordinary resolution, can resolve that the company shall sue. Yvette, you had any?
So in other words, so it's never a good idea for the director and the shareholders to be the same,
To have the same powers, yes.
be the same natural person.
Mm-hmm.
Right, I agree with everything you would have read, Ms. Archer, and said. I think it is important to understand the various roles of each constituency. The directors are charged with the overall strategic direction of the company. And when you have shareholders, if you have shareholders who may interfere with this, or arbitrarily, let's say arbitrarily interfere with this power, it will not make for the smooth running of the company. And so, I mean, that rule or that type of setup where directors, basically everybody stays in their own lane, is intended to ensure that the directors have the ability to do what is required to achieve the strategic objective of the company. If you have every time a shareholder or a block of shareholders which wish to pivot and make changes within the company, the directors won't be able to act for the betterment of the company. And so that's why the rules as such, or the articles are written, and company law is written in my experience to assist the directors as well as the shareholders when the need arises, but to primarily assist the directors in ensuring that they are able to carry out the strategic objectives of the company. And absolutely, there are some matters that are reserved for shareholders in general meeting that cannot be done with by the directors alone. And those things you would have indicated, like the setting of the auditors, for the ensuing year or the year to come. And also, in some cases, changing directors.
Yeah.
Yeah. So the power of the shareholders to make changes lies within their ability in general meeting to pass resolutions that that really could manage or control the things that directors may be doing that they don't think is appropriate or acceptable for the company. So that's where the shareholders' powers, as opposed to the directors' powers, lie, and that's an annual general meeting.
Mm-hmm. All right, so that was an easy one. I noticed from reviewing the answers, I think you all are going to do very well in this area in the final exam. I felt so confident when I read the answers. I said I should just take this out of the final exam, because you all know this part very well. You all should say yay.
So how is that? What is that question in the final exam?
I have not gotten there. Wait. Just
Oh.
wait.
Oh,
I will say yay.
yes, yay.
When I tell you all the areas to be covered in the final exam, then y'all can tell me yay again. Because it didn't sound like y'all were too enthused. Because normally when students are good at it in a particular area, they say, yes, put it on, not take it off. But anyhow, next one in the same area, explain the degree of skill and care which the law requires of a company director. And so Deshawn wrote, the Companies Act and the IBC Act both legislatively reinforce the general fiduciary duties of a director to manage the company, act honestly in good faith and in the best interest of the company, subject to the shareholder agreement and the memo and acts. Now, Deshawn, coming back to you. Let me see. Olivia put the same thing. Kadrin. The same thing. Kristen wrote that the duties of directors are to manage the company, act honestly in good faith, and in the best interest of the company based on its memo and odds. Directors should have the skills that a prudent person would exercise in such a position. Directors should not make a profit from his fiduciary position and not place themselves where there are conflicts, and should not act in their own benefit. And that is more or less the more direct answer. Whenever they ask you a question on explaining the degree of skill and care, which the law requires of a company director, you have to explain first that it is a fiduciary duty. And with that fiduciary duty, and one of them being that he was to make sure that whenever he acts in the best interest of the company, and also ensure that there are no conflicts of interest. That's one of the main things with that duty of skill and care in relation to the company director, that he doesn't act in conflict of interest. Anybody else want to add?
I would only be adding a clarification, a point of clarification.
Go ahead.
Absolutely, he is not to act in conflict of interest. With respect to, you said he must not profit himself. He must not profit himself. Let me say there's a caveat to not profiting oneself. There must be full disclosure with respect to any activity involved that the director may be involved in, that may benefit him, that the company, that he's not acting at arm's length with the company in. So there is a requirement for disclosure if there is going to be any benefit, but he must not actively act to his benefit and to the detriment of the company.
Right.
Yeah, I think there is even clarification in the Companies Act to that effect with respect to disclosure.
Yeah, he has to disclose.
Yes.
So that one was answered well, except for that last caveat, but that was okay. Does the secretary have a fiduciary duty to the company? I have yes. To act in good faith in the best interest of the company. Someone says, the Companies Act references the position of secretary as in its definition of an officer. Officers' duties states as they carry out the operational and daily mandate and activities of the company and oversee the supervision of critical corporate duties and responsibilities. Let's see, someone else wrote, yes, a secretary's fiduciary to the company is to carry out the operational and daily mandate and activities. The secretary normally answers to the board of a company. Under the IBC Act, in laying out the standard of care states that every director, officer, agent, and liquidator of a company in performing his function shall act honestly and in good faith with a view to the best interest of the company. Subject to the limitations of the memorandum or articles or in any unanimous shareholder agreement, each officer or agent has such powers and authority of the directors. And someone else wrote, yes, a secretary as an officer of the company owes duty to act in good faith and in the best interests of the company. Anybody want to add to that? On the secretary?
I think it's straightforward. My answer to that was shorter than the first one.
Okay. So the fiduciary duty of a secretary is similar to those of a director. Means that he cannot make any secret profits or take secret profits from his office. And if it happens, then he's required to account to the company as a constructive trustee. And you know that the appointment of the secretary is by the directors, and they may fix a term of office, or they may just leave it open and say the person just holds that position. So in the modern day, that's today's world, a company secretary is an important official, and they enjoy the power to contract on behalf of the company, even without authority. And this sometimes is confined to contracts in the administrative operations of the company. And then there are certain duties that are imposed upon the secretary by statute. And those would be submission of statutory declarations, annual returns, verification of statements. So the secretary has a duty, and that duty is to make sure that they're carrying out all of the regulatory requirements and meeting the obligations of the company. So they must have the requisite skills and knowledge and experience that comes with the job. So that one was very short. Now, multiple choice. The managing director of a company has usual or ostensible authority to bind the company by transaction he enters into on its behalf. Which of the following statements represents the limit of this authority? Someone gave me A. Someone gave me D. Someone else gave me B. And then I have D. So I have two Ds, a B and an A. So for those who didn't respond, what's your answer? Those who didn't turn one in, what's your answer?
I sound like the only one who didn't turn it in, eh?
No,
I definitely A. But I'm also looking at.
Why you
so
always,
okay. Pardon me?
why you always looking at two? You always,
I know. But definitely the managing director does all commercial matters which relate to the running of the business. That's his portfolio.
So what was-
What else?
no, you said you had another one. What's the other one?
I am also thinking about D, such commercial activities as the board may delegate to him. Wouldn't he also receive instructions from the board that, in addition to his actual portfolio?
Yeah, but they will be delegated to him by the board because the board knows that because it
Of his
is,
portfolio? Mhm.
What?
Okay, A then.
is A. The answer.
Okay.
So next one, Larry was employed as a cashier at Sandpit Limited. He entered into an agreement not to compete with Sandpit Limited for 6 months after leaving the company's employment. That agreement is a reasonable restraint of trade. Larry left and formed a company called Rockpit Limited and began to trade in sand, rock, cement, 1 mile away from Sandpit Limited, at which he had worked. Will Pitt Limited be able to get an injunction to prevent Larry and Rockpit from trading? I have an answer for A, B. For C, I have one for A, and C. What do you think?
I put A. Is that correct or not? I want to know.
I place A as well.
You pick A as well? Yeah, I see 2 A's here. Then I have a C. I have 2 C's. What do you think the answer?
You have 3 Cs.
3 C's. Okay, so C is correct.
Mm.
Okay, noted.
Don't forget now, you all asked for multiple choice on the final exam, and I put them there.
I think I like those multiple choice.
I don't think I voted that.
Well, you don't have to select. So next one, the register of directors and secretaries contain particulars of directors and secretaries. In the case of a director, these must include his what? I have 1B. I have 1D. I have 1A. And I have 2 A's. So what should be on it? A, B, C, or D?
I put D. Hold on,
Yeah,
let me check really quick. Make sure that's what I said. Yeah, I said D.
I
Mhm.
put D too.
You sure
They
that, right?
use their address. You should have their address. I mean,
Yeah,
the
because the
director's
other stuff, you don't
address.
have to put that there. And they're usually they're not usually there. Like sometimes they would say what their occupation is, but not the business address.
Should their address?
I put B, but from what I've seen, directors use both. I mean, either or. I don't
Yeah,
know what is the law requires, but I've seen them using either or.
Yeah, like sometimes they have it, but I don't think that's required. I think mainly their address, their like personal address is what's required.
Personal address, you sure is not their confidential business address?
I've never seen confidential business address. I've always seen their address, their personal address.
Me
Well,
too.
So I would be enlightened if it's not their personal address.
Yeah, so if you needed something else, that means the ones I've been seeing, they're wrong. They need to go fix that.
Okay.
What
Cadron,
is a confidential business address? There's no such thing.
they use the employer's address.
That's not confidential. Why is it confidential?
It's not theirs. Cadre-
Oh, that's okay.
Is Kadrin on?
Hi, yeah, Masachi, can you hear me?
Yes, yes. What do you normally see on the register of members?
I normally see the director's residential address.
And what about any other address? They don't put any other address?
Personally, I haven't noticed any other address, no.
Let me go to, I'm going to section.
Yeah, I picked A because I know we would normally use either one. And when I checked the act, it only said address. It didn't say which one.
Yeah, it just says addresses.
In my experience, it's always been the personal address, their residential personal address. Now, people get away with putting even Nassau, the Bahamas,
Yeah, that's all. They-
for locals.
Yeah.
But it's always been personal address, hence the follow-up with the utility bill to determine and confirm personal addresses. But, okay.
Yeah, it doesn't.
Yeah, because you can't use the utility bill to confirm your lawyer's address.
So the register of members may be in such form. No, it just says address. That's it. The names and addresses and occupation.
You're saying members, so the question say directors.
Oh, hold on.
Oh wait, it say, yeah, directors and secretaries. But the members is like the shareholders, that's different from the officers.
So which answer would be correct?
Hold on, 58. I'm going to it right now to see what it says in the return.
I didn't see anything that says whether it's residential or business.
That's
And I
correct.
have seen both, but that confidentiality is what got me away from A, because otherwise I would have selected A, but I selected D.
Usual residential, a business address.
Mhm.
Yeah, because it just says address. And that's it. So Amy has a service contract with Libby PLC for a fixed term of 10 years, which cannot be terminated by notice. The contract has been considered in general meeting. What is the position? I have an A.
Wait, hold on, so 6 is D?
Yes.
Okay, just being sure, okay.
So for Amy, I have D. I have
That's not 6, that's 7.
7. I have an A. I have another A. And this one, I have an A. Any other thoughts? Is the contract valid or void?
I put A.
I say it's valid.
Why?
It is valid.
It said it cannot be terminated by notice.
It can-
It's fixed. And it cannot be terminated.
Yeah, I mean, if it says that, how could they just say, well, okay, they could just terminate by any of the other reasons that were given for the other options?
But can you enter in a contract that says it cannot be terminated by notice?
I'm not sure, it depends on what the contracts say.
Okay, so listen,
It.
that is very vague. So notice in the employment, and if not vague, but if notice under the Employment Act speaks to a particular time frame that can be, or that should be given when dismissing an employee, right? Let's say it's an employee that you must give 2 weeks notice to. In the apps, if you draft a contract that says you do not have an employment contract that says you do not have to provide notice to the employee to dismiss them, that simply means that employee is contracting outside of the requirement to give them notice. And you could have a contract, an employment contract that says you can be severed without notice. And that would still be a contract that's not void. That's a legitimate contract. You just don't have to serve them with notice. You could tell them on a dime that, hey, this contract is up. You're terminated, or we're separating. And I don't owe you 2 weeks notice, or I don't owe you an agreed notice time frame. So that doesn't make the contract void. Now, if you were to say the contract cannot be terminated, or there is no ability to terminate the contract, then that contract is void, because contracts cannot exist without a out clause, so to speak, or the ability to cancel it. But you're not saying in this question that there is no ability at all. You just said there's no need for notice.
Right.
Yeah, but it also doesn't say that this is an employment contract. It may be another type of service.
Well, okay, I used an employment contract just to indicate a notice, but a defined notice period, but that's true of any contract. If you contract out of the necessity for a notice, then you've just given the person you're contracting with, or both parties would have agreed, that we can terminate this contract without providing either party notice. That doesn't mean the contract is void. It becomes void when you don't have the ability to cancel the contract at all. But that's not what this is saying. This is just saying it cannot be terminated by notice.
And you can just terminate it.
You can, I'm sorry?
You can just terminate it.
You can just terminate it. You know, I show up on your door one day and say, look, this finished. We done. I didn't have to give you notice. And I'm not outside of the terms of the contract, because the contract says it can't, what do you say? It's 10 years, which cannot be terminated by notice. So it's all that's saying is I don't have it. It cannot be terminated by notice. I don't have to give you notice. That's how I read it. Now, if there's a different construction.
No.
Okay.
So everybody got that one right.
No,
So
I didn't get that right. I selected A. So but you're telling me it's wrong.
No, it is A.
The contract is valid.
Oh, okay.
Oh, okay, okay.
See, it would,
Because
in my
you know my
estimation-
mother fixed around some more.
I was like, nah, they say A, I'm going with that. That's right.
Okay, so Sam, managing director of Buck Limited with a service contract for a term of 4 years. A group of shareholders is dissatisfied with Sam's conduct of the company's affairs to remove him from office. Advise to shareholders. So, Kristen says the shareholders will need to check his initial contract to confirm if there were any breaches with his. If Sam breach any of his duties as director, he may be removed. It can also remove Sam under the IBC Act, Section 42(3)(a), if the majority requests resignation. The company's articles of association would also state how he can be removed. Then I have an answer here by Deshawn. As shareholders, you have a privilege of appointing the managing director or removing him from office. However, you must be guided by the terms and conditions outlined in the memo and arts. In accordance with the Companies Act, Section 92, subsection 1, the members of a company may by resolution at an extraordinary general meeting remove any director from office. Who is this one? This is Kadrin. Kadrin says the shareholders should refer to the company's articles of association and shareholders agreement, as there may be procedures set out in the articles or provision in the director's service agreement where they are removed if they breach the terms of the service agreement. if shareholders are not satisfied with the conduct or performance of the director. And then she referred to the same section 92 subsection 1 in the Companies Act. And then she has here, the shareholder should seek legal advice as to how to successfully remove the managing director from office and how to terminate his employment contract on the grounds of poor performance or conduct. This is Olivia, says the shareholders can vote to remove directors from the board before their terms expire with or without cause, unless the corporation has a staggered board. The shareholders can then vote to replace the directors they removed. Articles 87 of the Companies Act, the members of a company may, by resolution, at an extraordinary general meeting, remove any directors from office. Where the holders of any class or series of shares of a company have an exclusive right to elect one or more directors, a director so elected may only be removed by an ordinary resolution at a meeting of the shareholders of that class or series of shares. So read the question again. Sam was appointed managing director with a service contract for a term of 4 years. A group of shareholders are dissatisfied with Sam's conduct of the company affairs and want to remove him. Advise the shareholders. Who has something different to say or want to add?
In my response, because I noticed in the question, it said a group of the shareholders. So
Yeah.
it didn't seem like, but all of the shareholders were saying this.
Mm-hmm.
So I also, similar to what everyone else said, I also said that based on the Articles of Association, we'll know whether majority or unanimous votes are needed to proceed with the change, you know, based on what is voted on in their meeting and when they're resolving to remove Sam as director and simultaneously appoint a new managing director.
Yeah. Anybody else? That's the first place you would go is to the articles. If you don't use the articles, then you can refer to table 8.
I agree with all of that.
Mm-hmm. So that was fun. So that's what this area of directors was very well done. When I read the answers, I said, this is done so well. I should not include it on the final exam.
No, I feel like it should be on the final exam because it would be inclusive of some of the chapters what are the final exam supposed to cover.
I just, we love to get a consensus.
I vote for Jolyn for president.
I second that.
We have to make sure that we know it properly, one more time, just put on the exam.
Oh, you're very well. Versus the one with the shares, with some people struggled. But it was very well done. I don't think I should even examine you on that area. You all were so good. Okay, let's go to the point.
So Ms. Archer, let me get some clarification.
Go ahead.
The point of the exam is not for us to show how good we are in a particular area. It's for us to not be able to answer the questions.
That is not true.
That's what I'm feeling. It's to show where we lack.
That is not true.
Yeah, that's how it seems.
You're supposed to be able to answer the questions on the exam.
Right, that's what I was hoping that was the intent. So if that is the intent, then we should see those questions.
You can see them.
And you said points from the homework goes towards our final exam, right?
Midterm or capstone. Midterm or capstone, any one of those.
Okay, so whichever one got the lesser score.
I will add it on to that and then of course there's something for class participation.
Okay, and how much is that?
10%.
Mm-hmm. And we get to choose which one we won't put that on.
No. what kind of choosing again? Anyhow, let's do liquidations and then I'm gonna tell you.
I feel like we should either get to choose or get a word box.
For what? Word box for what?
You say you haven't fill in the blanks on the final.
One bonus.
I feel like if we have a word box, then we'll get a, it'll help us, what direction you're trying to go with the paragraph you're forming, and it put the words in the appropriate spaces.
Okay, so you want a word
so you consume so much time completing the exam, coming up with words to put in these spaces.
That's a great idea. That's a great idea.
So this word box, let's say if the word is shares. In this word box, you'd want me have dividends, profit, shares, and you have to pick which one? Is that what you mean by word box?
Yes.
Or you would have shares twice, one with the correct
like
spelling.
if
and
the
one with the
blank
wrong
is
spelling.
Yeah.
One spelled S-H-A-R-E and one S-H-E-A-R. Right, Jolene?
I don't know. Me.
Yeah, like if there's 5 blank
I was
spaces,
thinking,
then
like,
you would
you know,
give
how
20
some blanks-
options, 20 names, 20 different words.
Yeah, I know how some blanks you might have like shares maybe twice, and so you put both shares in that box so that we could be able to know that you really did want us to put shares twice.
That's what you mean by box?
Yeah,
Okay.
we need a box that goes on the side. So when we have the paragraph and there's blanks in the paragraph, we refer to the box and we use the words only in that box to complete.
Okay.
So we don't be pulling out random words that you wasn't even looking for. We know exactly what you wanted.
Okay, and there's somewhere in that box.
Yes, in that box only.
Okay, I got you.
Okay, thank you.
So I'll put okay, so I'll just add word box. Let me put it now before I forget. I'm gonna put at the bottom here. I'll put it and then I'll put word box. Oh, okay, all right. I have it.
Thank you, ma'am.
Word box, that's the bonus. Okay, let's do liquidation. Now, when you do this chapter on this unit on liquidation, you need to have your company winding up act, the amendment, handy. So the first thing is definition of liquidation. You know, it's a process by which a company is dissolved and the assets and the property of the company are redistributed to creditors and shareholders in order of priority. Once dissolved, the company ceases to exist. And liquidation may also be referred to as winding up or dissolution, although dissolution is the last stage of liquidation. It should be noted that the winding up process is not exclusively directed towards realizing and distributing the net proceeds to creditors, and if anything is left, distributed to members of a company according to their respective priorities. Liquidation also enables a thorough examination of the conduct of the company's management to be undertaken. So there are 2 types of liquidation, voluntary and involuntary. Voluntary is where the members of the company resolve to voluntarily wind up the affairs of the company and dissolve it. Involuntary is where the process, the court makes a winding up order on the petition of a creditor or an aggrieved minority shareholder. Where the winding up of a company is commenced by a court order, the liquidator exercises his power under the direction of the court and is required to obtain the consent and or authorization of the court before entering into any transaction. You found the company's winding up amendment, 2011.
Yeah, I have that. Yeah, I have it.
Okay. So you need to peruse this for the final exam. Section 184 says a company may be wound up, A, compulsory by order of the court, B, voluntarily, and that's by virtue of a resolution, or because of an event has occurred, and the occurrence of its articles provide that the company shall be wound up, or 3, because the period, if any, fixed for the duration of the company by its article has expired. And the third way a company can be wound up is under the supervision of the court. So the court has jurisdiction to make winding up orders in respect of an existing company, a company incorporated and registered under the act, a body incorporated under any other law, and a foreign company, which has property located in the Bahamas, is carrying on business in the Bahamas, or is registered under Part 6 of the Companies Act. So the two types of voluntary liquidation is a member's voluntary liquidation or creditor's voluntary liquidation. So the members voluntary is a process where the directors and the shareholders, they decide to put the company into liquidation and the company is solvent. A creditor's voluntary liquidation is where the directors or the shareholders of a company decide to put the company into liquidation and the company is insolvent. So voluntary liquidation. Under Section 2 of the Winding Up Act, a company incorporated under the IBC Act may be wound up under any circumstances in which a company incorporated under the Companies Act may be wound up. So the Winding Up Act governed the voluntary liquidation of an IBC in the Bahamas, and an IBC can be compulsory wound up by the court, voluntarily wound up by resolution of its members, pursuant to the company's articles of association, or, like I said, expiration, or under the supervision of the court. So under Section 212, the voluntary liquidation of a company is deemed to commence at the time of the passing of the resolution authorizing such winding up, or on expiry of the period or the occurrence of an event, notwithstanding that a supervision order is subsequently made by the court. So what's the process for voluntary liquidation of an IBC? The resolution of the members of directors as required by the MEMS and ARTS that the affairs of the company should be wound up. A liquidator is appointed. The approval of a proposed plan of dissolution and execution of the articles of dissolution. The executed articles of dissolution are submitted to the registrar for registration. The date of the articles of dissolution is the date of commencement of the winding up of the IBC, unless articles of dissolution provide for another date, which shall be within 30 days of registration. The liquidator takes responsibility for winding up the company's affairs. So under the IBC winding up, the following provisions may be permissible in a liquidation. Interest on debts. A winding up interest is payable in accordance with the section on any debt proved in the winding up, including so much of any such debts as represents on the remainder of the debt. Any surplus remaining after the payment of the debts proved in a winding up shall, before being applied for any other purpose, be applied in paying interest on those debts in respect of the period during which they have been outstanding since the company went into liquidation. All interest under this section ranks equally, whether or not the debts on which it is payable ranked equally. The rate of interest payable, and no interest shall be payable if the liquidation is concluded in less than 6 months, or the accrued amount is less than $500. The liquidator advertises for creditors during the liquidation process. The notice of dissolution must be published within 30 days of registration of the articles of dissolution. The liquidator prepares a statement of account in respect of his actions and transactions in the liquidation process and forwards a copy to each member. The liquidator submits a statement of notice to the Registrar General that the winding up dissolution has been completed. The Registrar General strikes the company off the Register of Companies upon receipt of the notice, issues a certificate of dissolution, certifying that the company has been dissolved. The date of the certificate is the date of dissolution of the company. The liquidator publishes a notice that the company has been dissolved and has been struck off the register in the official gazette upon issuance of the certificate of dissolution. Now, a company, a creditor, a member, or liquidator may, within 5 years following the date of the striking off of the company, apply to the registrar to have the name restored to the register. And upon payment of the prescribed fee and all fees due under the Act, the company name can be restored to the register. If a company has been dissolved or the period of 5 years has expired, the company or creditor, member, or liquidator may apply to the court to have the name of the company restored to the register. An IBC may be struck off the company's register if it no longer satisfies the requirements of Section 14(1), 38(1), and 44 of the Act. A company struck off the register remains liable for all claims, debts, liabilities, and obligations of the company, and the striking off does not affect the liability of any of its members, directors, officers, or agents. A company that has been struck off the register still incurs liabilities. A creditor can bring a claim against the company, and the court may appoint an official liquidator. If the company is struck off under Section 165 and remains struck off continuously for a period of 5 years, the company shall be deemed dissolved. But the registrar may, if in the best interest of the Crown, apply to the court of the company liquidated and appoint an official liquidator. Now, involuntary liquidation. The winding up and dissolution of a company incorporated under the IBC Act may be wound up under the same circumstances as a company under the Companies Act. The circumstances in which a company may be wound up by the court are if A, the company passed a resolution, the company does not commence its business within a year from its incorporation, the company is insolvent, the members are reduced to a number to less than 2, the court is of the opinion that it is just and equitable that the company be wound up, or a regulator petitions for the winding up of a company which it has regulatory authority and whose license or registration has been suspended or revoked. Under Section 190 of the Companies Winding Up Act states that an application to the court for the winding up of a company can be made by petition presented by either the company after passing a resolution requiring the company to be bound up by the court, or any creditor or creditors, including any contingent or prospective creditor, any contributory or contributories, or a relevant regulator pursuant to regulatory laws, or where the articles expressly provide the directors to wind up the company without the sanction of a resolution passed at a general meeting. An application for winding up shall be determined by the court within 6 months of it being made, unless the court is satisfied that the special circumstances justify an extension not exceeding 6 months. Upon hearing the winding up petition, the court can either dismiss the petition, adjourn the hearing conditionally or unconditionally, make a provisional order, or make any other order that it thinks fit. But the court shall not refuse to make a winding up order on the ground only that the company's assets have been mortgaged or charged to an amount equal to or in excess of those assets. The role and responsibilities of the official liquidator and procedure for winding up under the supervision of the court as set out in the company's Winding Up Act. Now, winding up circumstances under which a company may be wound up involuntarily or voluntarily, compulsory by order of the court, voluntarily by virtue of a resolution, or because of the event has occurred, or because the period or any fixed duration by its article have expired. Under the supervision of the court. The circumstances under which a company may be wound up by the court, if the company has passed a resolution requiring the company to be wound up by the court, or if the company does not commence its business within a year since its incorporation, or suspends its business for a whole year, if the company is insolvent, the members are reduced in number to less than 2. The court is of the opinion that it is just and equitable that the company should be wound up, or a regulator petitions for the winding up of a company over which it has regulatory authority. And of course, the circumstances under which a company may be voluntarily wound up under section 211 is when the period, or if any, fixed for the duration of the company by its memo and articles expires. If the event of any occurs on the occurrence of which the memorandum or articles provide that the company is to be wound up. If the company resolves by resolution passed by a majority of not less than 3/4 of the members that it be wound up voluntarily, or if the company resolves by resolution that it would be wound up voluntarily because it is insolvent. So winding up under the Companies Act, first you need a resolution of the members to voluntarily wind up the company, or the expiry of the period or occurrence of an event. And that event has to be specified in the memo on or the arts. Automatic commencement by the liquidator as designated in the memo on arts, or if not automatically, the director shall convene a general meeting to appoint a liquidator. Consent to act is filed with the registrar, where the liquidator is appointed at the general meeting. Once a voluntary liquidator is appointed, all the powers of the director cease. A director or officer of the company may be appointed as a liquidator. A voluntary liquidator may be removed by a resolution passed by a general meeting of the company. A voluntary liquidator may resign by notice of resignation with the registrar. Within 28 days of the commencement of a voluntary winding up, the liquidator or the directors shall file a notice of the winding up with the registrar, file a liquidator's consent to act with the registrar, file a director's declaration of solvency with the registrar. In the case of a company carrying on regulated business, serve notice of winding up upon the relevant regulator, publish notice of winding up in the Gazette. A declaration of solvency means a voluntarily or affidavit in the prescribed form to the effect that full inquiry into the company's affairs have been made, and that to the best of the director's knowledge and belief, the company will be able to pay its debts in full, together with interest at the prescribed rate within such period, not exceeding 12 months from the commencement of the winding up, as may be specified in the declaration. So in the event the voluntary winding up continues more than 1 year, the liquidator shall summon a general meeting of the company at the end of the first year from the commencement of the winding up, and at the end of each succeeding year, and such meeting shall be held within 3 months of each anniversary of the commencement of the liquidation. At each meeting, a report and account of the liquidator's acts and dealings and conduct of the winding up shall be presented. Each report must contain information of the rates at which the liquidator's remuneration is calculated and particulars of the work done. 21 days before the final meeting, the liquidator shall send a notice specifying the time, the place, and object of the meeting to each contributory as per the company's articles and publish in the Gazette. As soon as the company's affairs are fully wound up, the liquidator shall call a general meeting to lay before the directors a report and account of the winding up, showing how it has been conducted and how the company's property has been disposed. No later than 7 days after the meeting, make a return to the registrar specifying the date upon which the meeting was held and confirmation of quorum, particulars of the resolution, if any, passed at the meeting. An application may be made to the court by a voluntary liquidator or contributory if there are any questions relative to the winding up of the company. If the court is satisfied and accedes to this application, an order may be issued. Within 7 days, the voluntary liquidator must forward a copy of the order to the registrar, who shall enter it in the records relation to the company. The voluntary liquidator is paid from the company's assets in priority to all other claims. The remuneration is fixed and payment is authorized by resolution of the company. So turn now to the company's winding up amendment. Turn to section 237, preferential debts. It says, notwithstanding anything contained in this act, in the winding up, there should be paid in priority to all other debts, all rates, taxes, assessments, or impositions posed or made under the provisions of any act, including sums due in respect of duty and penalties payable under the Customs Management. Any fees payable under the company's Winding Up Act, duties and penalties under the Stamp Act, and any license fees payable under the regulatory laws. And having become due and payable within 12 months next before the relevant date. Any sums due to the company to an employee, whether employed in the Bahamas or elsewhere, in respect of wages, salaries, and gratuities, and those accrued due during the 4 months immediately preceding the commencement of the winding up. All wages of any workman or laborer in respect of services rendered to the company during the 2 months before the relevant date. Any sum due and payable by the company on behalf of an employee in respect of medical health insurance premiums or pension fund contribution. Where a contract of employment has been terminated as a consequence of the company being wound up, any sum due by the company to any former employee in respect of severance pay and earned vacation leave. Unless the company is being wound up voluntarily, merely for the purpose of reconstruction or of amalgamation with another company, or unless the company has or at the commencement of the winding up under contract with insurers with rights capable of being transferred to and vested in the workman. All amounts due in respect of personal injury to workman accrued before the relevant date. And the debts referred to in subsection 1 rank equally among themselves and shall be paid in full unless the assets are insufficient to meet them, in which case they shall abate in equal proportions. And so far as the assets of the company available for payment of general creditors are insufficient to meet them, have priority over the claims of holders of debentures under any floating charge created by the company and be paid accordingly out of any property comprised in or subject to that charge. So notwithstanding section 232, or that a winding up order has been made, a creditor who has security over the whole or part of the assets of a company is entitled to enforce his security without leave of the court and without reference to the liquidator. Where the liquidator sells assets on behalf of a secured creditor, he is entitled to deduct from the proceeds of sale a sum by way of remuneration equivalent to that which is or would be payable under section 204. There's also a section here on fraudulent trading. On the application of a liquidator of a company, the court may make an order under subsection 2 where it is satisfied that at any time before the commencement of the winding up of the company, any of his business has been carried on with the intent to defraud creditors of the company or
Ms.
creditors.
Archer,
Yes,
I have a question for you
go ahead.
with respect to section 238, secured creditors.
Mm-hmm.
So this portion that says, a creditor, I guess a secured creditor, may, without reference to the court or to liquidator, call for his debt to be paid in the instance of a winding up, so does that mean to you that if there is let's say there is let's say it's a promoter or an individual who would have started the company, who would have entered into a charge over the assets of all of the assets of the company. In that instance, and the charge is still outstanding. In that instance, when there's a winding up, that particular promoter, investor, whatever, can take everything out of the company without reference to the liquidator and or the court.
But he's a promoter, so
Let's say he's an investor let's say he was an investor, same as in the gramophone case, say. Anyway, in the case, let's say he would have entered into a fixed charge over all of the assets of the company. And so therefore the company basically has a debt with him. And that debt is still outstanding at the time of the winding up. Section 2381 is saying to me that without having recourse to the court or to the liquidator, he can require that that debt be paid, which means that despite the fact that there are creditors out there who may not rank pari passu to him, he can go ahead and take everything out of the company, and nothing else can happen after that in terms of other persons being satisfied.
that's what it says. Let's go back to 232, section 232. Because it says notwithstanding section 232. So
Right.
232 says, this is a general provision. It says, subject to, of course, section 238, with effect from the commencement of the liquidation of a company, A, the liquidator has custody and control of the assets. We know that. The directors and other officers of the company remain in office, but they cease to have any duties, functions, or powers other than those required or permitted under this part. We know that. Unless the court otherwise orders, no share in the company may be transferred. No alteration may be made in the status of or to the rights or liabilities of a member, whether by any amendment of the memorandum or articles or otherwise. No member may exercise any power under the memo and articles, except for the purposes of the act. No amendment may be made to the memo and articles of the company. Any share capital that may not have been called upon shall be deemed to be an asset of the company. And be specifically debt due from each member to the company, and to the extent of any sums that may be unpaid on any shares held by him, and payable at such time as may be appointed by the liquidator. Anything or matter done or purported to be done in contravention of subsection 1 is void and of no effect. So 233.8 says, notwithstanding section 232, or that a winding up order has been made,
Right.
a court has security over the whole or part of the assets of a company. So to me, I think they're referring to when you have a debenture, because you would have security over the whole or part of the assets.
Right.
You're entitled to enforce.
Right. So well, I guess a smart and owner, majority shareholder, investor, whatever, who would have entered into an agreement, a mortgage, a debenture over the assets, that person really on the liquidation, no matter what, can take it all.
Yes.
Yeah.
Mm-hmm.
Yeah. Okay. I just wanted that point clarified for something I'm thinking about.
Mm-hmm.
Thank you. That's your view too, right? On that too?
Yes.
Mhm. Okay. All right,
As it has security over the whole or part, then it takes priority.
yeah,
Yeah.
all
And then-
right, thank you for that.
Right. And then 37 has the preferential debts. So that walks us right into the final exam. I think it's not too difficult. I think it's easy. You all are a smart crew. So let's see. This exam has how many parts? Don't get afraid with parts. This exam has 4 parts. Part A is mandatory. You have 2 questions. They're worth 15 points each. Part B, so that's what, 30. So part B, you have to choose 7 questions worth 10 points. Now I could change that and I can make part A with 2 questions worth 20 points each. And then part B, you'd only choose 6 questions. What do you wish? You prefer part A to have more points? Less
No, part A should be, as you said, because it would weigh too heavily for one part to have all of the points.
Okay.
We have to go by weighted average.
No one else said anything, so it is. It's typed in now.
But I mean, everybody should speak.
I'm waiting.
I agree with you there.
Yeah, I think it's too much, allocating too much to one question, one set of questions.
Okay. Part C may be completed to replace 1 question in B. You wanted to replace 1 or you wanted to replace 2? That's the multiple choice. I have 10 questions there. I can mark them as 1 point each, or I can mark them as 2 points each. So which one do you want?
2 points each.
Okay. Anybody else? No?
I agree, 2 points each.
Yeah, I agree.
B is still 7 questions?
Yeah.
Okay. B 7 questions, C 10 questions.
Yeah, multiple choice. C is multiple
Right.
choice.
Okay.
And then of course, D is the bonus question to fill in the blanks, and I'll give you a word box.
B is bonus.
Okay.
And how much is the bonus? That's worth 10 points or what?
I didn't put a point there yet.
But, for my clarification, all 7 questions are bonus questions or just?
No.
Okay.
You'll have in part probably about 9 questions, and you have to choose 7.
Okay.
So the bonus question should be worth how much? 5 or 10 points?
10.
10, all of that?
Agreed.
You
10.
did say
I think
5
the
or
bonus should be
10.
10. I think the bonus should be 10 points.
All of that?
It makes sense. And you suggested it.
Right, you said 5 or 10 points. Now we say 10 and you sound like you have a problem with our 10.
I'm thinking now, what you gotta jump straight for the 10. So if I get 10, can I take away the word box?
No, definitely not.
No, you can't take away the word box.
Non-negotiable.
Non-negotiable, non-starter.
Can't take the word box. That contract can't be void.
Okay, hold on. I'm writing it, and as we speak. Okay.
So the test is what, the last Saturday in the month?
Yeah, March 26th.
That's the last Sunday in the month. Oh, yes, 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 it is. Mhm.
Mhm.
Okay, so question. This
Go
still
ahead.
a sit-in exam, even though protocols haven't been eased.
Who said protocols have not been eased?
I didn't say anything about school. I saw seminars and what else? Concerts and all that good stuff. But I didn't say anything about schools.
Yeah, man. On the back end now. Just that I think they'll use like three or four classrooms. As long as you're 6 feet apart. All right, so now let's look at part A.
Have they considered just us doing it in our own environment and just having our cameras on?
You could ask. I know they've done it sometimes.
Yes, because I am questioning all this because I'm in the high risk category, and I don't really want to expose myself too much.
Speak to Mr. Price.
Okay,
Yeah.
all right.
Sure, he could arrange it. All right, so the mandatory questions. Let's see. One is on directors. The directors and looking at the articles, whether or not you need a resolution. The question will be similar to one of those you just did in your homework, talking about removal of a director. So that's one question with 15 points. The second question, mandatory question, is on liquidation. And in this one, I've given you 1, 2, 3, 4, 5. 5 little vignettes, and you need to tell me the priority of when they will be paid. How would a liquidator handle these? So of course, you're going to look at section 237 and 238 in the Company's Winding Up Act. So that's the two mandatory questions, 15 points each. In part B, where you choose 7, I have another question again on directors. That's one question. Then,
Sorry.
go
So
ahead.
part B, the short answer.
Yes.
Okay.
So one question is on shareholders and members. And of course, it's connected to a resolution to do something and whether they can do it or not, similar to the homework. There's a question on shares, share payment, similar to homework question. There's a question on risk and corporate governance. That's 3 so far, right? Then there is a question on money laundering. Very easy. It's just on the definition, the stages and the offenses, and what are the due diligence requirements to onboard a new IBC. Then we have another director's question. It's a little vignette with 1, 2, 3 little vignettes, and you have to discuss the validity of the transactions. So, you know, talking about a director and members doing things. Then you have, let me see, another risk question. From financial corporate service providers angle. You're looking at KYC and customer due diligence, and also a company's risk appetite. All that is in one question.
You said KYC and what?
KYC, customer due diligence requirements, and risk appetite. When you read a scenario, you'll be able to pick up the company's risk appetite. Then there's another question here on shares. But this one isn't directly on shares and alteration of capital or reduction of capital. This is looking at converting a partnership to a limited company. And they want the advantages and the restrictions. Then there is another director question. This one is on director acting in good faith. And acting in the best interest of the company. And you have to answer this one with cases. And then the last one in that section B is on liquidation. The kinds of liquidation and winding up. What a difference between the two. The order to distribute assets. And looking at restricting directors to form new companies when you're in a liquidation. That's part B. Not bad, right?
I just have, could you just, you said in liquidation, that last liquidation question, you said kinds of liquidation and winding up, difference between the two types, and then order to what assets?
Or the order to distribute the assets.
Oh, okay.
Yeah, so it's similar. The other one on liquidation in part B gives you certain actions, and then you have to give the priority. But in this one is asking you just simply in what order must a liquidator distribute the assets.
Okay. Mm-hmm.
And then the last part is looking at directors and whether they should be restricted in forming a company if they're in the middle of a liquidation.
Okay.
I have a
thank you.
question.
Got it.
Go ahead.
The capstone, do we bring that when we come to sit the exam or send it by email?
Send it to me by email.
Okay. And
Yeah.
this exam is 3 hours?
Yes, ma'am.
Okay.
Plenty time.
I don't know. It may not even be enough.
What you mean?
These questions look long.
You already have a clue how it's coming. These are short answers.
Okay.
And you can see that more than one is on the same topic. It's just taking it from different angles.
Okay.
So it depends on how you study. You may be able to answer 2 liquidation questions.
Mm.
Did you say we need to refer to cases?
Yeah, that question.
You mean in like the law cases that sometimes at the back of the units or?
Or in the notes itself. The
Oh.
question cases is the one where it says director should act in good faith and what he believes to be in the best interest of the company. And I want you to explain that using cases. What does that mean? What is that duty? Okay, part C is the multiple choice. And the multiple choice is coming from directors, on directors again. I think they have it on directors. Yeah. It's directors, and then I have 2 of the multiple choice is on liquidation. So all the rest is on directors.
And you said this is 10 questions in the multiple choice?
Yes, 10. Oh, in part B, I'll add another question in here just in case. I'll add something. Remember the handout I gave you on the shareholders agreement? You remember the handout I emailed?
Yeah, I remember.
Yes.
Okay. I'll put a question
Yeah,
on the
we have
shareholders
that one.
agreement.
Is this a multiple choice question?
No, short answer.
Okay. And this coming under which section?
B.
Okay.
Ms. Archer, I didn't get the handout.
How come? Everybody got it.
I'm not sure. I don't see it in my email. I'm looking.
I sent that on that same week. If you don't, then I'll have to send it to you. Anyone has it handy?
Which week, if you don't mind me asking?
That would have been, when did we do shares?
It was sent by Miguel on February 17th.
Oh, see, I know some of us could be quick. Yeah, because we did shares the 12th and we send it after. So I'll add in B a question on shareholder agreements.
I did not get that from Miguel.
You didn't?
No, ma'am. All I see is the 12th, 14th, and the 19th.
Oh, we missed you out.
Yes, ma'am.
Can you send it to Olivia? Please?
Yes, ma'am.
Okay.
Okay.
What's your
So I
email,
think
Olivia?
My email is olongley@lanobahamas.com. I'll type it in the chat.
Okay.
yeah. So I think I give you all a, that's okay, right?
You were talking about section C, multiple choice 10 questions. 8 was
Yeah.
on directors and 2 was on liquidations.
Yes. So you have in B, you have questions on directors, liquidation, shareholders agreement, AML, shares. So I narrowed it down as much as I could. Yeah. And we agreed you'll do 7.
There's the section D. You said 4 sections. 4
Yeah,
parts.
D is the bonus.
Bonus.
That's the bonus for 10 points.
Okay.
Fill in the blank, and I'm gonna give you a word box.
Yeah.
Okay?
I have a question about the capstone. Is that mandatory?
It has points assigned to it.
So, I mean, if we don't send it in, then you just don't get the points allocated.
Correct.
And how many points?
Hold on.
This is overall points for the entire course.
Yeah.
Okay.
Oh, hold on. I can tell you right now. Let me go to my beginning.
The capstone is worth 15%.
Oh, well.
Sound like you don't intend to do the capstone.
This month ended up being bad for me because I ended up being called on a few matters. One is very significant before the Court of Appeal, so I don't have the benefit of the time I thought I would have.
Well, at least put something down. It's better than getting 0.
I don't know about
When was
that.
this capstone sent?
Yeah,
Put something down.
all right. I'll have to
What'd you say the capstone percentage is?
15.
Where you see that?
That's extremely significant.
Where
It's
did you
on-
see that
it's-
15%?
It's on the manual, right after the course syllabus. It has the course assessment.
Okay, all right. My own doesn't say that.
So it has 10% for participation, 15 for the capstone, 25 for the midterm, and 50% for the final exam.
Okay, hold on. You said that too fast. Class is 10. I have that. Capstone is what?
15%.
Uh-huh.
Midterm, 25%.
Oh, I didn't have the burn term. Okay. And the final is 50.
50, yes.
Okay. All right. That's good to go.
And you said
So you
anything
know,
about online final.
yeah, just email Miguel.
Okay.
Email Miguel. All right, and then we're good to go. I think I've given you all the areas.
Ms. Archer, there's a word limitation on the capstone?
No,
Okay,
no.
all right.
Yeah. So everybody is good. Everybody on the same page. Part A, 2 mandatory questions, 15 points each. Part B, 7 questions worth 10 points each. Part C may be completed to replace 2 questions in Part B. And D is the bonus for 10 points. I won't make the one on the shareholders agreement too difficult. I'm thinking of there's probably looking at the advantages and disadvantages of having a shareholders agreement and maybe something else. Nothing too complicated.
You said something at the end of your explanation of part C, I believe, you said may be completed to replace 2 questions in part B. What was that? Or
Yes.
was that?
Yes,
That's for,
correct. You're correct.
you said that with respect to part C?
Part C, yes.
So part is not mandatory. That's,
Part C, you don't have to do it.
you can replace it. Okay,
Yeah, you could just do 7 questions in B and that's it.
I got it.
Right. But if you wish, you could do 5 and then answer part C.
Got it. Okay.
Yeah.
All right. Thank you for that.
Okay, no problem. Any more questions?
Where are we sitting this exam again now? At where? Where's the
At
location?
Biff's
Oh, I have to find out where that is. Okay.
on Shirley Street in the Graham Thompson buildings. You know where Graham Thompson parking lot is?
Opposite the hospital?
Yes. You park in the parking lot and walk across the Graham Thompson building. You'll see a corridor and you walk through there and you'll see the sign for the institute.
And if they do agree to have it online, by when will they let us know?
You'll have to ask Mr. Pratt. So you should send that email to him today or first thing Monday morning.
Okay, thank you.
Okay.
Right. I'm sending it right now. One from me for sure.
If we do have to go in, this is a handwritten exam, or do we need to carry our laptops? Do we have?
Handwritten.
Oh, Lord. So y'all also have to decipher my handwriting?
Oh, is it that bad?
So we can need more than 3 hours.
Yes. These days, everyone have electronic signatures. I can't even write my signature no more. You expect me to write whole essays?
If your handwriting is that bad, you need to speak to Mr. Pratt again to see if he'll give you a laptop to use. Ask
I
him.
mean, each of us, I'm sure, have our own laptop. This is like very archaic now. This is like
exactly
a horse and carriage. We way beyond that point now.
Speak to Mr. Pratt.
And then if we're using our laptops, we might as well just not come in person to,
Ask
Yeah, but I
him.
guess it's because it's supposed to be a closed book, so I guess that's why they don't want us to use laptops.
But I mean, that's I've just sat a major exam, and I did it online and with the camera set up, and I mean,
I know he has done it with the camera set up. I don't know if he's ever done it for a large class. But he has done it.
we have to get with it. I mean, we are lagging.
Class ain't large. Class ain't that large.
No, it's not that large. But I don't remember him ever saying he had a class this size and he did that. So you'll have to ask him. But he's recording, so he'll hear everything he said.
Okay, I'm dropping off an email asking as well.
Yes, Miguel, I'll be emailing you, asking for a to sit my exam at home via camera.
He heard you.
Since you're listening, we do appreciate the work.
All right, but still send the email though. Still send the email. All right.
It's been a pleasure. It's been a pleasure. It's been a pleasure, Miss Archer.
You're most welcome. I'm still waiting on some more midterms. I assume I will get them soon, sometime this week. As I mark them, I can send you your midterm grades. If you wish.
Oh, sounds scary.
Oh, please.
Yes, please send and we'll know.
You wouldn't know.
Yeah, so we have an idea where we stand in right now.
Right.
That only be one leg. You need other legs.
I
Well,
know,
at
but at
least-
least we know what we're doing with the midterm.
Okay.
Yeah,
All
and
right.
we'll know how do we got it accordingly for the final.
Okay. All right.
on.
All right. I'm just waiting on a few more. Once I get those, I'll mark them.
Ms. Archer, if we
Yes.
have any questions, will you be checking your email?
Yeah, man.
Okay.
That's not a problem. I'll check my email. Well, I'm always checking it because I have other classes, so I'll be there. All right, so we good? Everybody's happy?
Yeah, I think we're good. I gotta see how I study now.
Okay. All right.
I have to organize the time to do so.
Well, that's the first thing. Organize the time. You know what's coming on the exam, so you go from there. I think so. I'm trying to get this done.
And the
Okay.
finals is only unit 6 to 10, right?
Yeah.
Everything that's on the finals. Okay.
And I already gave you the topics, so you know.
I feel like I need to start from unit 1, but okay.
Why you gotta start from unit 1?
Because I feel like I'm missing some stuff.
What stuff?
That's just how I feel. Like I
You don't
haven't done
understand.
enough.
Oh no. You overthinking. We agreed.
Yes,
That would
ma'am.
only be on the pass, on those sections right there. That's it.
Okay, thank you,
So
ma'am.
stop stressing.
Lolita,
I'm-
like
I
they
say that
said,
I-
we have to organize our time between work and doing our keystone and and studying. We have to organize our time for the next 2 weeks.
Yep, right at the end of the tunnel.
Yes.
In
Well, the
terms
light
of
is
the
there.
cases that we would need to reference, I mean, I don't know where to start from there. Is that going to be, are you going to give us some sample of what type of cases we need to
I
reference?
can do that.
So I would know.
I can do
where-
that for part A and B. I can give you some cases.
All right, that would be good.
Yeah. I can give you some cases.
Okay, somebody was scared to ask this question.
Uh-huh.
They want to know if they could take in the act.
No, of course not. What do you need to take in the act for?
I mean, that does make sense because in application, like in the real world, you'll have access to the acts at any time to refer to.
Yeah, but I mean, these questions don't call for no specific sections.
Okay.
No.
Also,
I
we don't
mean-
have to reference the sections in the acts and
No,
answering.
no.
Okay,
Yeah,
just
we have to do
general
all-
knowledge based
yeah.
on what we know from it.
Right.
Okay.
So you already know in your head what the act says for a director's fiduciary duty. It's a duty of skill and care. Yeah, you know that. I don't need to know the section.
Okay. Noted.
Yeah, so you don't need that. You don't need that. You all are getting frightened for no reason. Stay calm. There's no surprises. Exactly what I said is exactly what's going to be on the exam. Only thing you don't know is the bonus question. That's the only thing. Everything else, you know. And we had already agreed that the bonus question has to be something that's written in the manual. Remember? So I have that there. Okay, so we good to go? We're
And
good
we
to go.
agreed that the bonus question was 10 points?
Yes, I already recorded it.
Okay, thank you.
Yeah, it's 10 points. And I have your word box, so I'll put a word box together. Yep. So that's it. Start preparing. And the time is going to go up very quickly. So don't procrastinate. All right?
All right.
Okay.
Thank you,
So enjoy
ma'am.
the rest of your weekend.
Okay.
You
All
too.
right.
Bye,
Okay.
everyone.
Okay, bye.
Okay,
See
good
y'all on the, see
afternoon.
y'all on the
Goodbye.
25th.
Okay, bye, everyone.
Take care.
26.
Yes.
26, yeah.
Okay.
Alrighty.
All right.
Enjoy.
26. Okay.
Good afternoon.
Good afternoon.
Good day.
Good day.
All right, good day. Have a good weekend, Ms.
Good day. You too, Kadrian.
Good afternoon, everyone.
Good afternoon.